2006. I joined the course, finished it in 2011. I did it from Pune University, from Ferguson Law College. And I always knew that I wanted to get into litigation. So that one thing I was always clear about. So when I joined the firm, because I'm a first generation lawyer in my family, so to be very honest, I had no clue what to do. So I went there, joined a law firm in Delhi, worked there for a few years, and when I realized that this is now time where I can manage to handle cases on my own, so I started my own independent practice. Now it's been almost 4 5 years by God's grace, and here I am. So see, it's it depends on person to person. It's very subjective. You can't decide when to leave a firm, when to start off your own. There are friends in the fraternity who would start at the age of just after passing out. There are people who, even after 10 years of their, law degree being completed, is still working with one form or the other. So it's a personal call, I would say. It just, it just clicks someday that you want to do something of your own now. And though I still have a very amicable relationship with my, the firm I used to work with, all the people I used to work with. So that's about it.
All right, sir.
Yeah,
So, sir, let's straight away jump into the
yeah,
nitty-gritties of the topic.
yeah,
What is the investigation procedure in money laundering matters by the Enforcement Directorate? Can you explain
yeah,
it to us step by step?
yeah, yeah. So yeah, now this aspect of money laundering. Before getting into the topic, I must congratulate LawSikho and its team. You guys are doing a wonderful job during these unfortunate times, and I hope everybody who's watching this webinar is doing and keeping up safe, and above all, maintaining social distance. So now, as we all know, today's topic of discussion that I've been invited to talk about is investigation process in money laundering matters. Now, before I get into the law part of it, the statute which governs this, let us see what is the brief history. Because we are short on time, it's very difficult to capture each and every aspect of this statute. But still, I'll try to give a bird's eye view of this law, whatever I know from my own experience. Now, this Money Laundering Act, which in India, the Prevention of Money Laundering Act of 2002 governs the field. That is the act which per se criminalizes the offense of money laundering as such. Before that, now how this term coined all over the world, what exactly happened? They say that the term money laundering has its recognition from the term laundromat. Now, what is the meaning of this laundromat? Way back in the year 1920s and 1930s, when this drug trafficking business was at its peak, a lot of people who were generating illicit money out of their illegal trades and all, they used to take care of their cash component by investing in one business or the other. Like we had bootlegging and all those things. And in the year 1971 or 72, the famous Watergate scandal broke out in the US, where the then US President Dr. Richard, he was named in the scam. He also subsequently resigned. So what happened? That led to a series of legislations being passed at that point of time. But as far as this Money Laundering Act is concerned, the US passed this legislation by the name of Money Laundering Control Act of 1986. Now, thereafter, soon thereafter, the international community was also very, cognizant of the fact that all over the countries, all over the world, this menace of drug trafficking and terrorism, the illegal funding part was at its peak. Now, thereafter, so in the year 1989, they, an international community was formed by the what we call it as G7 countries like France, Germany, UK, US, to name the few. And they formed an entity called Financial Action Task Force. Now, this FATF, what it did, it suggested some recommendations all over the world to control this aspect of primarily drug trafficking, the money generated out of that trade, as well as the terrorism part of it. Because at that point of time, at least in India, there was no legislation to that effect. Though at that during that point of time, in the year 1985, we had NDPS Act, which was specifically, dealing with the aspect of narcotics and all that. And keeping in mind that people were generating a lot of illegal money out of drug trafficking business, terrorism funding and all, there was a very important amendment, I would say, in the NDPS Act at that point of time in India, and Chapter 5A was incorporated. Now, Chapter 5A dealt with the forfeiture of properties which were generated out of the illegal trade of narcotics. Again, till that point of time, there was no aspect of money laundering in India, at least. And only in the year 1998, a bill was introduced in India by the name of Prevention of Money Laundering Bill of 1998. The bill was referred to standing committee. It went on, referred. There were some changes suggested, and finally it took the shape of the act in the year 2002-2003. But unfortunately, it never came into force. So the central legislation of Prevention of Money Laundering Act, which governs the field in India, it came into force only on 1st July 2005. Before that, we did not have any offense which per se was criminalizing the offense of money laundering. Only after this act, by the dint of Section 3 of this very statute, the offense was made punishable. Before that, though we had a lot of legislations, like we had, Foreign Exchange Management Act, we had FERA Act, we had Custom Act, then we had Coffee Posa Act, then we had SAFEMA Act, NDPS Act was there. But all those acts were dealing with the particular offenses which were made punishable in those. None of those acts were taking care of money laundering aspect as such. Now, if we see what is this money laundering all about? Now, in simple terms, the aspect of money laundering, if I have to explain, this is like converting illegitimate money into legitimate money. It's like you project that, your money is clean, but however you have derived that money out of some proceeds of crime, like some offense was committed. Anubhav, you're there?
Yes, sir, I'm right here. Actually, there's some problem with my webcam. Please, you continue.
Yeah. So now what happened thereafter, once this act was... Hello?
Yeah.
So once this act was, came into force in 2005, I would say this is one of the acts which has been a very contentious legislation in India. As we speak, there is always an evolving law, but as far as this particular aspect is statute is concerned, every day there has been literally a new judgment coming from one high court or the other, and there is a change of scenario altogether. Now, the act itself went into a lot of amendments. There was a major amendment in the year 2005 itself when the act came into force. After that, in 2009, there were a lot of amendments in the act. 2013, there were amendments. 2015, there were amendments in the act. Again, 2018. Then as late as in 2019 also, there have been some major amendments done in the Act. And I would say the major provisions of the Act, which we deal in on daily basis before the courts, are still sub judice before the Honorable High Court or Supreme Court, at least, so as to say. Now, what I was explaining before I get into the Act part, what the Act talks about, in common parlance, like I was explaining, the term money laundering means that you project that your illegitimate money is absolutely clean. Now, primarily the aspect of money laundering involves 3-4 steps, as we understand. The first and the foremost step is, of course, the aspect of generation of illegal money. Like if I sell narcotics, drugs, I get some pecuniary benefit out of it, I generate some cash. That's called the generation of illegal money. Now that itself is not a money laundering. Thereafter, if I, generate some money, second step, as we call it, we infuse the money into the system. That a lot of people also term it as placement, what we, understand the term as. So once we generate the proceeds of crime, we infuse it in the system, and we somehow trying to legitimize it through one way or the other. Thereafter, we have the process of converting and routing that legitimate money, which we are trying to show legitimate, through different financial transaction, interbanking, corporate transaction, so that the original source is concealed. That's called routing or concealment or layering of the transaction. And finally, once the layering is done, we somehow invest the money in a project so as to give an impression that this is the money, this is absolutely clean money. For example, I'll give you an example. I say Mr. X is a public servant. He gets, say, 50 crores for a, doing a favor to a particular company. Now somehow he has number of bogey companies in the name of his relatives or friends. He gets that money routed in those companies, then from one company to another, then another to third, and finally he invests that particular aspect of, transaction of 50 crore finally into a real estate project. Now the moment it is given in the shape of a real estate project from where the flats are constructed, the illegal money, which was initially a money for, doing a favor to a particular entity, that was corrupted money, or we say as, in simple terms, bribe, that got converted into legitimate money. And the person projected as if he's trying to build, he's into construction business, and this entire process is, we call it as money laundering in simple terms. Now, this very statute is one of the most peculiar legislation that I have at least come across, and you will not find any other offense, any other statute which is similar to this act. And one of the most peculiar part of this, statute is that this statute is not, an independent offense, so as to call it.
Precisely.
Like, for example, what happens is, as we all know, God forbid, tomorrow there is a commission of murder. Now, the moment murder is committed, there has to be an FIR. The commission of murder, the police investigating authorities will not depend on anybody else to register an FIR. जो हम simple language में कहते हैं कि जी पर्चा कट गया. So, as and when there is a commission of cognizable offence, there has to be a mandatory FIR being registered by the concerned police authorities under section 154 of CRPC, which is the base criminal procedure code which governs the, our as far as offences of Indian Penal Code are concerned. But in money laundering cases, that's not the picture. Now, in money laundering cases, what happens is, the moment there is an allegation of money laundering aspect, say some authorities gets to know that there is some angle of money laundering being involved, before an investigation is initiated in Money Laundering Act, there has to have a predicate offense, we call it, before an investigation commences in Money Laundering Act. Now, what is this predicate offense? Predicate offense is a schedule offense, or in simple terms, let us call it as a parent offense. It's like the mother offense. Now, unless or until that mother offense is there in existence, there cannot be any investigation under Money Laundering Act. Now, what happens, like I'll give you an example. If there is a commission of murder in a fit of anger, now that does not have any money angle involved in that. Now, that per se will not be an offense so as to initiate an investigation under Money Laundering Act. Now, like I said, in a case of simple 302, which is, the relevant statute so far as cognizable offences under IPC are concerned, straight away there will be an FIR under murder case by the concerned police authorities. Now, unless that mother offence is registered by that authority which is investigating that offence, you cannot come to the angle of money laundering. It's like, I'll give you another example. If you would see the statute itself. Now, what this statute says, it gives a schedule at the bottom of the act. Now, this schedule enumerates as many as 30 different statutes, which are, the central legislation governing in the country. For example, we have Prevention of Corruption Act, we have Narcotics, NDPS Act, Narcotics, Drugs and Psychotropic Substances Act. Then we have Explosive Act. Then we have Indian Penal Code offenses. Then we have Custom Act. Then we have Companies Act. So unless there is commission of an offense in only one of those 30 statutes which are mentioned in the schedule of this act, only then there could have been a possibility of starting an investigation in the Money Laundering Act. That's why I said that money laundering, the act itself is a derivative act. It is like a baby act. The parent act would be the schedule offense. Schedule offense is what? Schedule is offense is something which is mentioned in the body. If you would, now I've been told that there are a lot of law students also who are presently watching this webinar. Yeah. For their understanding, I would say, if you would, once you are through with this webinar, if you would just go through the schedule of this act, that schedule has around, like I said, 29, 30 different statutes provided in the schedule itself. So unless one of those offenses is already committed, there is already an investigation going on under those offenses, the money laundering angle cannot kick in. So now, as far as the money laundering part is concerned, it is not necessary that in every money laundering case or in every schedule offense case, there has to have a money laundering angle. It's like, there can be a simpliciter murder case also. The moment murder is happening, or let's take an example of, because it's an economic offense, let's take an example of Corruption Act case only. Now, suppose a public servant commits, he takes bribe from somebody, he enters into this illegitimate act of corruption, and thereafter he gets caught, or there is an allegations for him that he's entering into this exercise of corruption and all that. So obviously there will be an FIR, and Central Bureau of Investigation is the central agency which will investigate that offense. CBI will start the investigation in that offense. They will do their independent offense investigation. Now, if you generate some money out of that offense and you try to launder that money, how do you launder that money? You invest that money by buying a property in somebody else's name. Now, here is the laundering angle involved. Now, the moment laundering angle comes into picture, the concerned authorities under PMLA Act kicks in. And what they do initially is that they register an ECIR so as to understand the term. In normal cases of IPC, we have the offenses of, we have FIR, first information report, what we call it. But in cases of money laundering, the prerequisite is ECIR. That's like enforcement case information report. Now, what happens in this ECIR? This is nothing but you can say a brief allegation as to why the investigation has started. What is the base allegation? Now, one of the fundamental aspects of this very provision, which is registration of ECIR under Section 3 of the Money Laundering Act, is also is concerned. In normal cases, the moment FIR is registered, unless it is a Sexual Offences Act case or an offence which is dealing with the national integrity or anything of that sort, the police has to mandatorily supply a copy of that FIR to the accused who's named in the FIR. Now, one of the another heated, I would say contentious issues, which is also sub judice before the Honorable Supreme Court on this aspect, is that whether once ECIR is registered, ECIR is the first document before investigation kicks in by the concerned authorities. So once ECIR is registered by the authorities, they don't share this copy of this ECIR with the accused person. Now just imagine the position of an accused person, that he knows, or he gets a telephone call, or he receives a notice or summons under Section 50 of the Act, which is the relevant provision, that boss, again, there is offense being registered. What are the allegations in the offense or in the case? We will not tell you, but you have to be present at particular time in our office. Now that gentleman would obviously will not understand why is this happening, what is the angle. And when he will go and ask for a copy of the ECIR, he will be told that you can't be given a copy of the ECIR because that's a privileged document. Now, in various cases, this issue has also hit the courts, at least in Delhi High Court and some other high courts as well, that can you direct the Enforcement Directorate, who is the investigating authority under PMLA Act, to supply a copy of the ECIR to the accused persons, unlike in a case of normal cognizable offense like murder or an corruption act or something of that sort. So this issue is also yet to be tested and yet to be given laid rest to. So once ECIR is registered, the offense of money laundering kicks in. Now, if you would go through the definition of money laundering, before this last amendment, which came in the year 2019, I think it came into force in the month of August 2019. The definition of money laundering had two aspects, as if we see the act, the central legislation which governs the field. One is that, like I said, there has to be commission of schedule offense, like the parent offense, the mother offense, which is what any of those offenses mentioned in the schedule of the PMLA Act, any of those 30 statutes which are mentioned in the schedule of the Act. There has to have a commission of that offense. From that offense, there has to have a proceed of crime, so as to term it. Now, that proceed of crime, that's the second fundamental aspect of money laundering definition, what this act talks about. And the third most important aspect of this act is that you have to project these proceeds of crime as untainted. Now, interestingly, earlier, the word which was being used was and in the definition, but now this and has been interestingly used as or. Now, what is the fallout of this amendment in the year 2019 is that earlier the so-called offender has to be connected with the property which is generated out of the any criminal activity related to a schedule offense. And second was that he also has to project it as if this is absolutely untainted money. But now, subsequent to the amendment, this second part has been given a go by. Now, what this amendment does, this amendment of 2019, it says that even if you are in mere possession of the proceeds of crime, then also you can be roped in for an offense of money laundering. Now, what happens? Just imagine all of us, for once in life at least, we would purchase a property from our hard-earned money. We would go buy something from our money. We enter into a legal transaction. And 10 years down the line, we get to know that this property, before I purchased it, the erstwhile owner had this property, being obtained through proceeds of crime, through some criminal activity committed by him in the past. And he had invested the money, the profits that he had generated out of that money into this building, or a flat or a shop or anything of that sort, or a floor which I purchased subsequently. And now the concerned authorities are after my life that now you are in possession of this, so hence you are answerable to face the music. Yeah. So this is a very peculiar aspect, and it would be interesting to see how courts would take cognizance of this particular amendment, because like I said, this amendment would also be a trouble for those bona fide purchasers who enter into legitimate transactions with the erstwhile owners without even knowing that the erstwhile owner has done some illegitimate act in the past. Now, so this is one angle of the section 3 of the Act. Now, section 3 of the Act, as the definition would explain, is intrinsically linked with section 2(1)(u) of the Act as well. Now, 2(1)(u) of the Act defines this term proceeds of crime.
Do you want me to open these Bare Acts or these statutes on my laptop?
Yeah, why not? Why don't you just flash this section 3, if you can have it on the screen for
Section 3 of Finance Act 2019, right?
No, the section 3 of the PMLA Act. Do you have it?
Yeah, I do.
Hmm.
Section 3. Right, yeah, got it. Sir,
Yeah.
please go ahead. Here is your uh, section.
Uh, I can't read the entire. Wait, I'll just. Yeah. So as you can see from the screen, the Section 3 of the Act says whosoever directly or indirectly attempts to indulge or knowingly assist or knowingly is a party or is actually involved in any process or activity of crime, including its concealment, possession, acquisition, or use, and projecting or claiming it as untainted, shall be guilty of offense of money laundering. Then there
Yeah,
is there is an explanation which has been added by this amendment of 2019. Uh, Anubhav, I can't access this. There is some words are missing from the page here.
Ajay.
Nevertheless, I'll just explain like I have just explained the gist of the act. The gist of the act prior to the amendment, like I said, was that first there has to be proceeds of crime generated out of a schedule offense, and second, those proceeds of crime ought to be projected as untainted. These were two fundamental aspects of the offense of money laundering. Now, after the amendment, this and has been replaced by or, and couple of explanations have been added in the act. Now, the fallout of this, like I said, is that now even if you are in mere possession of proceeds of crime, and even if somebody is not even entering into an exercise of projecting it as tainted or untainted money, then also he can be roped in for an offense of section 3, that's money laundering. Now, if we see the definition of money laundering, you have to understand the definition of proceeds of crime. Unless you understand the definition of proceeds of crime, the definition of the offense of money laundering cannot be understood. If you would just flash 2-1U for a minute. Yeah.
Yeah,
Now, proceeds of crime means any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a schedule offense, or value of such property, or where such property is taken or held outside the country than the property equivalent in value held within India or abroad. Now, there are three aspects to this definition. One is that there has to be a property which is generated, obtained directly or indirectly by a person as a result of criminal activity committed in the schedule offense, which is the parent offense. Like I gave an example, in a corruption act, there is a corruption, there is somebody has been given bribe. So he is generating some proceeds of crime for an act of corruption. Now, if you would see the schedule, PC Act, Prevention of Corruption Act, we call it as PC Act in normal, in regular courts and all. PC Act is one of the schedule offenses under the Act. So once there is a commission of corruption, PC Act offense, as mentioned in the schedule, the first part of proceeds of crime stands satisfied. And only thereafter we come to the second part of the definition of section 3, which is that you also have to project it as untainted money, which, like I said, now has been given a go by, and it has been replaced with the word or by way of this new amendment in the year 2019. Now, the second part of proceeds of crime is value of any such property. Now, this value of any such property means that supposedly you took cash from somebody, say, for example, Mr. X was involved in an offense of selling narcotics to people. He used to take cash from them. That's the proceed of crime that he's generating from the schedule offense. Why? Because NDPS is a schedule offense. It's like one of the parents offense, or you can say as a listed offense. Schedule means listed offense or a parent offense or a predicate offense, because it is mentioned in the list mentioned in the act. So if Mr. X sells narcotics to somebody and takes cash out of it, he is committing a schedule offense. Now, the moment schedule offense is committed, the authorities related to NDPS, like we have Narcotics Control Bureau, NCB, we have DRI, they usually, investigate those offenses. Straight away, that investigation will kick in if the allegation is there of, or the person gets caught. So the first part is taken care of. Now, this money which he has taken while selling the narcotics is the first angle of, proceeds of crime. Now, supposedly that Mr. X invests that money into some other property. Say he purchases some property through one way or the other, and the cash which was the original proceed of crime is now gone. So the original proceed of crime has been converted into a property which he purchased. So this definition which talks about value of such property, in this case would be that property that he purchases from the cash that he received from the sale of that narcotics drugs. Now that part can be taken care of by the second part of this proceeds of crime. So this way he's trying to launder the proceeds of crime which he has committed through, by entering into this act of selling of narcotics, but still he's trying to enter into this illegitimate act of laundering. But the moment he projects that part as if it is untainted money, the angle of money laundering will kick in. So this is the angle of money laundering and the definition of proceeds of crime. And if you would now just see which authorities under the act are, I would say, empowered to investigate offenses under PMLA Act, because investigation, once it is started after the registration of an ECIR, like I said, under section 3, which is nothing but an FIR in normal parlance. जैसे हम जनरली हम कहते हैं कि जी एक FIR कट गई, तो इस केस में आप लोग समझ सकते हैं कि this is like, ECIR कट गई is like akin to FIR. It is like an FIR for money laundering cases. But again, the sine qua non, the prerequisite for registration of ECIR is that there has to be a schedule offense. Unless that schedule offense is there, the ECIR cannot, the investigation cannot kick in. Now, who would investigate offenses under this act? Interestingly, when this act came into force, the act did not provide that which is the authority which will investigate the offense under this act. The act always used the term like director, assistant directors, and there is a specific section also under the act, I think 48 or 49, 48, which says who are the authorities. And one section 54 of the act is also very important, which says that which authorities, central authorities in India, would assist the investigating authority of this act. Now, interestingly, Enforcement Directorate is also mentioned as one of the authorities under section 54, which was initially, the ambit of the act was that all these, if you would just, Anubhav can show section 54 for a minute on the screen. Yeah. So you can see the following. Yeah, that's it. Officers and others are hereby empowered and required to assist the authorities in the enforcement of this act. Now, if you would just see, the Enforcement Directorate is also one of the authorities mentioned in these. Just scroll down a bit, you would see section 54. Yeah. Yeah, here, G. So if you would just see G subclause of this, officers of enforcement appointed under FEMA Act of 1999. Now, like I said, when this act was enacted, the Enforcement Directorate officer themselves were required to assist the authorities, which were supposed to be, it might have been some, the initial, I would say, intention would have been to constitute a separate central agency altogether, which was supposed to be assisted by the authorities mentioned under Section 54. But when the Act came into force in the year 2005, the Enforcement Directorate was given the power, and even till today, the ED authorities are the authorities who investigate the offences under the Money Laundering Act. So this is again an issue which was there before the court, because Enforcement Directorate initially was never empowered under the Act to be the main authority to investigate offences in this Act. Now, like I said, the moment ECIR is registered, ED authorities kick in. And what they say, what they do is they send you, or whoever they feel that there is a suspicion against an accused person for commission of any laundering aspect. Section 50 is very important. Section 50 notice or summons, we call it, would be dispatched to that person without disclosing that what is the allegation, why his presence or some documents are required from that gentleman. Straight away, Section 50 would kick in, and he will be directed to be present at the office, or he might be asked to submit some documents from the his company or his possession, which are in his possession, to the authorities. Now, the biggest problem that the person would feel is that he would not know what is the allegation against him. Why is he being called to the investigating authorities office? What is he supposed to do? And plus, obviously, it is an offense wherein the ED authorities are also empowered to arrest. So his liberty can be put at stake, and he can be arrested for that matter. So what does he do in that scenario? So that's another fundamental core issue which is being bothering the courts, that whether, like I said initially, the copy of the ECIR is to be first provided to the concerned accused person or not, so that he can properly defend himself before a court of law. Now, once Section 50 is served upon an accused person, a notice under Section 50 is served upon an accused person that Mr. So-and-so is required to be present before a ED authority on a particular date, he is under a bound down duty to be present at the office at that offense. Now, the interesting part of Section 50 is that this is different from a normal statement given to a cop. Like in normal offenses of Indian Penal Code, we see any statement given to a cop by an accused is not admissible in law. That is hit by Section 25 of Indian Evidence Act, and as well as 162 of CRPC, which says that anything, unless or until there is a subsequent discovery, that's a different chapter altogether. Like, pursuant to my statement, something was recovered by the cops, then to that extent it might become admissible. But the major part of the statement per se will be inadmissible in law. But in ED offenses, like PML offenses, you say whatever to the ED authorities, that would stand admissible in law by the dint of Section 50 of the Act. Now, because this Section 50, if you would just see Section 50, these are proceedings which are deemed to be judicial proceedings within the meaning of Section 193 and 228 of Indian Penal Code. Now, what does it mean? Now, similar provisions are there in Custom Act. We have, I think, 108 or 104 under Custom Act. I'll just have a glass of water. Yeah. So once a Section 50 notice is served upon a gentleman, first of all, obviously his liberty is at stake. He obviously, seeks some legal advice and tries to get into the aspect whether his liberty at stake or not. Liberty should be secured first, whether he should go for the aspect of anticipatory bail or not, whether he can be arrested, his house can be raided or not. So those are the moot questions that obviously crop up in the mind of any person who is asked to be present in ED's office, which obviously is a very powerful agency and one of the most empowered agencies in the country as on today. So once Section 50 notice is served, the person goes to the office of the ED authorities and his statement is recorded. Tomorrow, if he resigns from that statement, he can also be liable to punishment under Section 193 for giving false evidence of Indian Penal Code. So the dilemma starts is that how does he prepare for his defense without even knowing what is the allegation against him or what is the offense against him? So what usually people do is that they seek direction, they go for writ petition before high courts that please, the authorities may be directed to provide us a copy of the ECIR so that we can build up upon the defense. This is all an investigation process, though I must say, I did not point it out earlier. There is a different angle of attachment of properties also provided in the Act. That's altogether a different chapter, which I'll touch a bit later, because right now I'm primarily dealing with the investigation process part. Because the Act primarily deals with two aspects. First is the aspect of investigation leading to a prosecution in a court of law. That's a criminal offense. Other aspect is, like I said, the forfeiture attachment of the property, which has been generated out of the proceeds of crime of a schedule of offense, like a predicate offense or a parent offense. Now, the aspect of prosecution is obviously more, people find it more deadly, I would say, reason being that your liberty is at stake. And if you would also see section 19 of the Act, that section provides for the provision of arrest to the ED authorities. Now, the very peculiar aspect of this section is, though this provision is also been challenged before the courts on a number of occasions on different propositions, the provision, if you can just flash for a minute, Anubhav, section 19 of the Act, for everybody's understanding.
Sir, it's right here on the screen.
Yeah. So the provision says that if the director, deputy director, assistant director, or any officer authorized by so and so has reason to believe, the reason for such belief to be recorded in writing that any person has been guilty of an offense, he may arrest such person and shall as soon as may be inform him of the grounds of such arrest. Now, the very peculiar aspect of this provision is that this is slightly different from normal provisions of, I would say, the power of arrest in different offenses. In this provision, the pedestal has to be of guilty of committing of offense. That means that before an officer ventures into the act of arresting somebody who is, alleged to be involved in an aspect of money laundering, he has to have sufficient reasons to believe that that person, quote unquote, is guilty of an offense. So the parameters set up in the Act is quite high as compared to other acts where this guilty of offense word is not mentioned. Usually it is generally that, where like in IPC offenses, we have section 41, where the language uses suspicion, reasonable suspicion, reasonable belief. Those words are mentioned. But here the words which are mentioned is guilty of an offense. But what happens in these offenses is that the moment somebody, because these are economic offenses, usually the magnitude of offenses is quite high. And obviously in offenses of economic nature, the aspect of anticipatory bail is almost negligible. We have a famous case of Mr. P. Chidambaram as late as latest as in the month of October, November of 2019, when he had tried to seek anticipatory bail before the Honorable Supreme Court. But again, the Honorable Supreme Court was of the view in that case that in money laundering cases, because it's an economic offense, the anticipatory bail should not be given regularly, in a routine manner, because the very exercise of anticipatory bail is unique in nature. It's an extraordinary exercise which the courts, if there is an order in affirmative, indulges into. So the aspect of anticipatory bail in money laundering cases is almost negligible. So the person has no option but to, if he gets arrested, because ED authorities have the power to straight away go for an arrest if they want to arrest somebody and record his statement under section 50, which would be subsequently during the stage of trial would be admissible in law, then the person would definitely be under trouble. Now, section 19 has to be read with section 45 of this Act. Now, these two sections, if you can just flash section 45 of the Act for a minute.
Right here, sir. Dhruv, sir.
Yeah,
Yeah.
yeah. So section 45, if you would just see, it says that offenses to be cognizable and non-bailable in nature. This very section is also, I would say, there can be a separate session for this very section, I would say, because when this act was enacted in the year 2003 and the act came into force in the year 2005, initially the word cognizable were removed from the act. But interestingly, from the heading of the act, the word cognizable were never removed. So there was a debate on this issue that whether cognizable offenses, the offenses under the act are cognizable offenses or non-cognizable, cognizable offenses. Now, what is the meaning of this cognizable or non-cognizable offenses? That also we need to understand before, in order to understand the mandate of arrest under PMLA Act or not. Cognizable offenses and non-cognizable offenses are defined under CRPC 1973, which is the base legislation for offenses under Indian Penal Code. Cognizable offenses means that offenses where the concerned authorities have the power to arrest you without seeking any warrant from any court. It's like a suo motu power that they have. Usually in common language, I would say these are more serious offenses, and non-cognizable offenses are those offenses where the authority has to seek a warrant from a concerned magisterial court before, and only then they can venture into the exercise of arresting an accused person. Now, in this act, when this act was initially, enacted, this provision was introduced in the act, but the very language of the provision was changed when it came into force in the year 2005, and the word cognizable was removed. Now, in a lot of cases, this debate took place that once the word cognizable offenses in the sections 45 of this act has been removed, then the offenses become non-cognizable in nature. This is one of the arguments which have been taken by defense lawyers in a number of cases. We also had the privilege to be assisting counsels in a number of cases where we dealt with these aspects of the law. So the moment it becomes non-cognizable in nature, the authorities, the ED authorities' power to arrest suo motu to an accused person goes away. Now if at all, there is a lot of debate on this issue, whether it's cognizable in nature, whether it's non-cognizable in nature, and that issue is also still pending in Supreme Court. So the moment, if this proposition was upheld, that this is non-cognizable in nature, the ED authorities would lose the option of arresting somebody without seeking a permission of the magistrate, because this mandatorily, because it's a non-cognizable offense, they have to seek permission of the magistrate, which definitely would be I would say a difficult situation for the authorities to deal with. And one landmark judgment, I would say, Nikesh Tarachand in the year 2017, Honorable Supreme Court, any discussion on PMLA is incomplete unless every student of law, be it a practicing lawyer or a budding lawyer or a law student, deals or reads this particular judgment of Nikesh Tarachand, passed by the Honorable Supreme Court in the year 2017 by Honorable Mr. Justice Rohinton Nariman Saab, where section 19 and 45 especially was discussed to the hilt. And finally, the conclusion was that second subclause of this section was set aside. Now, as we speak today, until the amendment of 2019, this second subclause of this provision was struck down by the Honorable Supreme Court. So you can say that this was non-existing in the statute. And there is also a debate on this, because what happened once it was struck down by the Honorable Supreme Court in the year 2017, the concerned authorities brought an amendment in the year 2018, and they said, we have resurrected this very provision, and now the aspect which was struck down by the Honorable Supreme Court stands revived. On this issue, also, the debate is still pending before the Honorable Supreme Court, and the final issue is still, yet to be decided. And finally, in the year 2019 also, the amendment says, if you would just read, that's why the amendment also says that offenses have always been cognizable. If you would just, Anubhav,
Yes, sir.
slash the explanation at the bottom of this section. The explanation, yeah, for removal of doubts, yes. So if you would note, yes, thank you. If you would note the explanation of this act, which is, which has been brought into the act in the year 2019, says that it is clarified that expression offenses to be cognizable and non-bailable shall mean and meant that all offenses under this act shall be cognizable and non-bailable, notwithstanding anything contrary to, CRPC, and accordingly the offenses are authorized to. I think I just skipped the one part because I can't see the entire portion. Just 1 minute. I think somewhere it says that it's always been, yes. If you can just reduce the font. Yeah. So yeah. So in the explanation, in the very first line, if you would just see, it says that it after shall mean and shall be deemed to have always mean cognizable. That is why this clarification was brought into the act, that see, according to the prosecution authorities, this act, these offenses have always been cognizable in nature, meaning thereby that they always had the power to arrest suo moto. They don't need any magistrate's order for that. And this argument taken by defense lawyers in various cases that these are non-cognizable offenses and hence you need a magistrate warrant for that does not hold any water. That is why the moment arrest aspect is dealt with under section 9, every lawyer comes to the aspect of section 45 also, where the argument by relying upon the judgment of Nikesh Tarachand passed in the year 2017, the lawyers argue that the act has always, the conditions mentioned in the subclause 2 of this act has been struck down. Now these conditions, if you would see, in this act, there are two conditions, twin conditions we call it as, which have been enacted in the provision, which was finally struck down in this judgment, which I was referring to, Nikesh Tarachand. Now, these two conditions were what? One was before a person goes to the court. Now, this is here right now, like I said, we have crossed the stage of anticipatory bail. And we assume that once the ECIR was registered, the person could not get an positive order on anticipatory bail. He stands arrested under section 90 by the ED authorities. Now the gentleman goes to the concerned accused person goes to the court and he says that, sir, please release me on regular bail, because this deals with the regular bail aspect. Now the moment this aspect comes into picture, before this was struck down in the year 2017, the prosecution used to take an argument that apart from the fact that the offenses have been cognizable in nature, they also used to say that there are twin conditions mentioned in the provision. One was that the person has to prove, if you can just go to section 45 again for a minute, subclause 2 of this provision. Yes, the upper one. Subsection 1 and subclause 2, where the prosecutor opposes the application and court is satisfied. Now, these two conditions were very important. If you would just see, the court is satisfied that there are reasonable grounds for believing that, number one, he is not guilty of such offense. This is the first condition, which the accused had to satisfy to the court of law, that he is, sir, not guilty of offense. So the paramount presumption of law, what we all take in all criminal matters, that everybody is presumed innocent until proven guilty, that goes for a toss, especially by looking into this provision. One is what? That he has to prove while seeking bail from a court where he is arrested, that number one, he is not guilty of such offense. Second, that he is not likely to commit an offense if released on bail. Now, the funny part of this, I would say, was, like I said, that every money laundering case money laundering offense is dependent on a predicate offense. There cannot be an existence of money laundering offense unless there is existence of a schedule offense, the parent offense, which can be one of the offenses as mentioned in the schedule of the act. Now, supposedly somebody, let's take an example of, simpliciter murder case again. If somebody is arrested for a schedule offense, that would be investigated by normal police authorities. So it's like two different offenses, like I said, two different agencies are investigating the concerned offenses. Police will be investigating the offense of murder. They will not be concerned with the proceeds of crime part. The laundering part, the proceeds of crime generated out of that and subsequently laundered by that would be taken care of by the money laundering authorities, which would be a separate offense, which would be a separate, investigation altogether. So the accused person, if the person is accused in both the offenses, he has to seek bail twice in two different offenses because these are two different offenses. So in murder case, he does not have to prove that he is not guilty of such offense. He only has to satisfy the base conditions of section 439 of CRPC, where the fundamental parameters are nature and gravity of offense, the likelihood of not facing the investigation, running away from the trial, tampering with evidence. But he doesn't have to prove while seeking bail in that main offense, that the parent offense, that sir, he will not, he's not guilty of offense. But in a baby offense like money laundering, which is dependent on the schedule offense, he has to prove that he is not guilty of such an offense. So that was one of the anomaly which was considered by the Honorable Supreme Court in the case of this Nikesh Tarachand in 2017, leading to a judgment to the extent that these two conditions were struck down by the Honorable Supreme Court. That no, the person does not have to prove that he is not guilty of an offense. He only has to satisfy the basic bail condition, just like in a normal case, which are covenanted in section 439 of CRPC. Like what are those conditions? Nature and gravity offense, the likelihood of facing the trial. Yeah, Anubhav, I think you're trying to.
No, sir. Please carry on.
Yeah. So this is the aspect of, again, one judgment, which is very important for the aspect of, I would say, money laundering, especially for the bail aspect, is Raj Bhushan Om Prakash Dikshit, passed by the Division Bench of Honorable Delhi High Court, which again is sub judice before the Honorable Supreme Court. Like I said, this is one of the most contentious legislation that any lawyer, or for that matter, any defense lawyer or a prosecution lawyer would ever come across, because major aspects of this law are still sub judice in Supreme Court. Like one angle, like I just explained, the aspect of whether the offenses are per se cognizable in nature or they are non-cognizable in nature. The fallout of would be that whether the concerned ED authorities have the suo motu power to arrest somebody without seeking a warrant from the magistrate, or do they have no power to arrest somebody without seeking a warrant from the concerned magistrate. Another angle is obviously of this twin conditions of section 45, where earlier and even till today, prosecution always makes an argument that, sir, he has to satisfy that he is not guilty of such an offense, because practically this aspect cannot be proved by an accused at an initial stage of the trial, that he is not guilty of such an offense. That aspect would obviously be decided at the fag end of the trial, whether he is guilty of the offense, he is not guilty of the offense, which obviously, and you can't say that till that point of time, the person will remain in incarceration. That can't be the intent of law to my understanding. And that's why in 2018, after this provision was struck down by the Honorable Supreme Court in the year 2017 in Nikesh Tarachand, 2018 amendment came into picture, which said that now we have revived the twin condition. And one of the argument was raised that once the Honorable Supreme Court strikes down a particular provision of law, you can't revive it again. That's again one of the arguments that in cases which are sub judice on this aspect are pending in Honorable Supreme Court. Again in 2019, another follow-up amendment was passed by the through Finance Act of 2019, where again it was reiterated by the authorities that it has always been cognizable in nature. So again and again, they are trying to say that this is cognizable in nature. The defense have been trying to argue that this is non-cognizable in nature. The very act, when it was framed in the year 2005, it was the very provision of word cognizable was deleted from the provision, but unfortunately the heading was never amended. That also led to a lot of absurdity in the act. So all these issues are pending before the concerned, before the Honorable Supreme Court in this Rajbhushan Om Prakash Dikshit judgment also, which is pending before the Supreme Court, and hopefully a judgment would come soon on this aspect. So this was the angle of investigation so far as criminal offense of money laundering is concerned. One is, like I said, to break it down in simple terms, I would say, first is the registration of the parent offense, that's the predicate offense, that's the schedule offense, that's the listed offense, one of the offenses mentioned in the schedule of the act. Unless there is a commission of that offense, there cannot be a money laundering offense. That's the first aspect. After that FIR or whatever case is registered, a complaint in the schedule offense, there can be an ECIR in the money laundering case if there is an angle of money laundering involved in that. Now, thereafter, the ED authorities have the option of starting their investigation. They send notices under Section 50, the statements of which are admissible under law, unlike a police statement in an Indian Penal Code offense, where it is hit by Section 25, 162, which is inadmissible in law, except to the extent of disclosure statement, like I said, statement leading to a recovery under 27 of Indian Evidence Act. So all these statements are per se admissible in law. Thereafter, straight away, the liberty of the person, gets into trouble. He goes for, if at all, he chooses the route of anticipatory bail. The chances are almost negligible because these are usually economic offenses of higher magnitude. The courts are not inclined to grant bail in such cases, and the person is arrested. Thereafter, he goes into custody, and Section 45, Section 19, all these, Nikesh Tarachand's judgment, Rajbhushan Om Prakash Dikshit judgment, all these judgments come into play. The amendment of 2018 issue that whether once the amendment was struck down, the act was struck down in 2017, so far as 45 twin conditions are concerned, can you revive those conditions again and say, no, they are still existing in the statute? So that's the aspect of investigation. Whereafter, once the investigation is concluded, obviously the ED authorities files a final complaint in the concerned court of law. Now that concerned court of law is defined under the Act, under Section 43 of the Act. These are special courts which are designated sessions court, and only designated sessions court can be, can try an offense under Money Laundering Act. Thereafter, the offenses are tried before a designated sessions court, and the matter goes for a trial. That's a subsequent stage. That's a different topic. I would not touch it right now because I think we're already quite over time on the.
Yeah, sir. So it's a great, very well detailed answer on the investigation process of money laundering matters. So here I would like to invite some questions from our audience.
Yeah.
So people, all the questions, can you guys please type it in the chat box of our YouTube live? The Zoom chat is disabled. So can you guys please type it in the YouTube live chat? I will be taking. Most of the questions are, sir, pertaining to the attachment of property.
Property.
Okay. Yeah.
Yeah.
So
I
first is,
wanted to touch
can
that
any
topic.
property
Yeah, go ahead.
can any property be attached under the PMLA prior to the registration of FIR for the predicate offense?
I just lost you. Can you repeat the question, Anubhav, once again?
Question is, it is by Parvaz Kazi. Can any property be attached under the PMLA prior to the registration of FIR for the predicate offense, for the scheduled offense or the predicate offense as we call it?
See, the process of attachment is dealt with in Chapter 3 of the Act from Section 5 onwards. Now, attachment, there are three aspects of attachment. First is, and the foremost is provisional attachment, we call it, which is done by the ED authorities during the course of investigation. Second, we have Section 8, wherein the concerned adjudicating authority confirms the attachment. That's called adjudication/confirmation. And thereafter, we have possession of the property, by the ED authorities. And fourth step involved is confiscation of the property, which is done by the concerned special court where the offences are being tried. So, like I said, unless there is a predicate offence, there cannot be an investigation in money laundering offences. So the prerequisite is that there has to be a schedule offence. So now earlier what used to happen in section 5, if you would just see, the provisional attachment provision is there, that is section 5 of the Act. There are two provisos. The fundamental aspect of attachment. Attachment is what? Attachment is like a restraining order by the ED authorities to the concerned person that now onwards you will not alienate, transfer this property to anybody else. Now, under what circumstances this attachment can be done by the ED authorities is that if they feel that the proceeds of crime, the property which they feel is generated out of proceeds of crime, it's related to money laundering aspect, that property is likely to be, transferred or concealed in a manner that subsequently the property is not available to face the, as far as the angle of money laundering is concerned, to defeat the very purpose of the Act. So hence the provision of attachment is there. Now there are two provisos in this provision. One is proviso 1, which says that there cannot be any attachment first, that is what we call it as provisional attachment, unless there is a final report or a charge sheet under section 173 of CRPC in the predicate offense. Now that proviso is succeeded by a second proviso, which is usually exercised by the ED authority, which says that notwithstanding what is contained in the first proviso, if the ED authorities is of the opinion that there is an immediate requirement of attaching the property, even if there is no, 173 report being filed before the concerned court in the schedule offense, then the ED authorities can definitely attach the property. But again, the registration of FIR in the predicate offense is a necessity, because without that, there can't be a money laundering aspect. But the filing of final report under 173 is not an absolute necessity. The ED authorities can definitely go for the second proviso, and it says that if they feel that the property is likely to be transferred or alienated and the purpose of very act would be defeated, hence they can straight away go for attachment of property, which is yet to be confirmed or adjudicated by the higher authority under section 8 of the Act.
Understood. So great answer. So sir, next question is from Nitin Mittal. So Nitin, all right, I am unmuting you. Please ask a question.
Hi Dhruv, this is Nitin here. I'm part of the BFSI industry. Thank you for this insightful session. This was very nice. So I'm part of the compliance team, and as part of my role, I sometimes look into the AML aspect as well. Can you hear me?
Yeah,
loud and clear.
Okay, perfect. So you did talk about the schedule offenses, and that has to be a critical component for any kind of investigation into PMLA. Now, what if the jurisdiction of that offense, scheduled offense, it's outside of India? What will happen to PMLA? And the other stages which you talked about, the placement, the layering, and the integration, reside in India? What will happen in that case? Because as part of our monitoring process over transactions at the bank, what we do is we do look into transactions, how they're happening, whether they're part of the money laundering. So if the original offense, for example, let's say there's a drug cartel going on in Colombia and the money proceeds are coming to India and they're getting placed in India. So how will you talk about the scope? Can you elaborate a little bit on that?
Yeah, sure. See,
thank you.
As far as cross-border transactions are concerned, that's also been taken care of in the Act itself. There is a part C in the schedule of the Act, which specifically says that in cases of cross-border transactions, if some proceeds of crime are involved, then also the authorities can start their investigation. Now, what are these cross-border transactions? That's also defined under the Act, under section 2 of the Act, which says that anything which is happening outside the country, supposedly if somebody generates some money out of India and subsequently he wires that money to India, then the concerned authorities can definitely track that money. And for that, we have, a specific intelligence agency as well, Financial Intelligence Unit of India, which was constituted in the year 2004, where primarily the role of that agency was seeking intelligence from various banking financial institutes, from, you can say, intermediaries like, sub brokers who are registered with SEBI or NBFCs. So these are all entities which are under the PMLA Act required to report to this FIU, Financial Intelligence Unit, and in case of any suspicious transaction. So Section 12 takes care of that transaction, that scenario where any foreign transaction is involved. If at all some entity, some bank, some NBFC suspects that there is some, suspicious financial transaction, they are under a bound-on duty to report it to FIU, which can further transmit the information to ED authorities and they can investigate further on that. Plus, apart from this, we have Section 57 under PMLA Act, which talks about the investigation which ED authorities are empowered under the Act to do in cases of cross-border financial transaction. Now, these are called letter of request. Now, what are these letters? This is a separate chapter altogether under the Act, which specifically deals with foreign transaction, like I said, cross-border transactions, where the ED authorities, once they suspect that, yes, there is a cross-border money laundering happening and something is being funded or coming from abroad to India through one way or the other, then through 57, they have to say the concerned court in India, which will be this designated sessions court, will have to send a request to that particular country where this laundering aspect or this generation of proceeds of crime is taking place. And that country we term in the Act as contracting state. Now that country, namely contracting state, would have to follow the procedure. If there is a treaty between that country and India, that treaty would be followed. If there is no treaty with such country, then the basic request that will be sent from the concerned court in India to that concerned court in that very country through the process of Ministry of External Affairs or Finance Ministry. And the process would be, any evidence, any documents that would be received from that country would be finally treated as evidence in the investigation, which would be done by investigating authorities in India. I hope that suffices your question. Can you hear me? Yeah.
Yes, absolutely. Thank you so much. That's very helpful.
Yeah, Anubhav. Anubhav, I can't hear you.
Yeah, now. So his question is,
Just
as I told ED, what is this question?
Yeah.
So I think he's saying that if ED doesn't need to take permission to arrest, do they also don't need permission to do a raid?
Yes. Now, again, I did not elaborate on the raid part due to paucity of time, because again, that's again a topic which,
Demands a separate session.
Yeah. So as for a raid, in common parlance, we say somebody is raided. Like usually we connect it with income tax issues. कि भाई किसी के घर में God forbid raid हो गई. Now, this raid term is per se not defined either in Income Tax Act or in PMLA. Now, even the ED authorities has the power to raid, like in common parlance we call it. Now, what is this raid? This raid has primarily two aspects, we can say, as far as the Act is concerned. One is under Section 16 of the Act, which talks about survey. That's the survey part. Section 17 talks about search. Now, both can be termed as raid in common parlance. Now, what happens is that, like I said, the moment ECIR is registered, the ED authorities also has the power to raid a premises or to go for a survey under Section 16 or a search of a premises under Section 17. There is a slight difference between survey and search, but let's take an example of search, which is like a raid only. Now, what happens in Section 17? There is a recent amendment in 2019 again on this issue, and I'm sure this issue will also hit the court soon on this particular aspect about taking permission before going for a search or not. Before this amendment of 2019 in Section 17, it talks about searches of premises of people who are suspected to have been in possession of proceeds of crime. There has to have a mandatory report under 157 of CRPC. There was a proviso under Section 17 before the amendment of 2019. The meaning of that is that Section 157 of CRPC means, you can say in simple terms, that there has to have an FIR of under 154 of the predicate offense. So you don't really need a permission of the magistrate for that. The only requirement was, prior to the amendment, that there has to be only a commission of schedule offense which is being registered under by the concerned authorities under 154. They did not need any permission, and only requirement was a report being forwarded under 157 of the concerned criminal procedure code. Now, after this amendment of 2019, this proviso has been deleted. Now, the fallout of this deletion is that right now, just like Section 19, ED authorities, if we take this amendment as it is as on today, do not need any permission to go for any raid or search or survey from any concerned magistrate. The only requirement would be that there has to be a schedule offense, the registration of FIR in the main offense, that's the predicate offense. But if tomorrow courts come to a conclusion that in the judgment of Raj Bhushan Om Prakash Dikshit and some other judgments which are tagged along with that judgment before the Honorable Supreme Court, that the offenses are non-cognizable in nature, then definitely there will be a change in scenario. But as on today, they don't need permission of magistrate. Earlier, the prerequisite was registration of FIR, that's it. But now even that has also been given a go by, and let's see how that would be taken care of by the courts.
Okay, all right, sir. So, sir, another question is from Rishabh Tiwari. For a person to seek bail, does he have to prove that he is not guilty of offense under the Parent Act as well? Since an offense is not considered under PMLA unless there is an offense under the Parent Act, unless there is an offense established in Scheduled Act, or he is asking it to elaborate it by an example.
Yeah, sure. So the answer is no, because like I just gave an example earlier in the case of Nikesh Tarachan, where a similar example has been directly mentioned in the judgment itself, that supposedly, I'll give another example, say for an offense of cheating. Cheating is one of the offenses mentioned in the Schedule Act. Let's take a simple example of cheating, which is punishable under the Act, Indian Penal Code under 417. And this has also been made an predicate offense, schedule offense in the PMLA. Now, if somebody is arrested for an offense of cheating or the aggravated form of cheating, which is 420 of IPC, which is punishable up to 7 years, he does not have to prove that he is quote unquote not guilty of an offense. The only thing he has to prove is the parameters as laid down in 437, because it's a magisterial offense, which are what, like I explained earlier, that nature and gravity of offense, he will not flee away from justice, he will not try to tamper with evidence, he will be available to the investigating authorities and all those things. The basic parameters of bail when we go for regular bail. But in case of PMLA, imagine a person who is accused of, as far as predicate offense is concerned, cheating. Now in PMLA, if this twin condition was not set aside, he will have to show that he is not guilty of PMLA, though in the parent offense, he is not supposed to show that he is not guilty of that offense. So the genesis offense, he doesn't have to show to the contrary, but in the baby offense, he has to show to the contrary if the argument of the investigating authorities is accepted, which I feel has already been dealt with in the judgment of Nikesh Tarachand, and that particular word has been set aside, has been struck down. Though, like I said earlier, in 2018 and 19, the argument of ED authorities has been that they have revived those conditions. So their case will always be that, sir, now he'll have to prove he's not. So the yardstick has been increased. So I think that suffices if. Yeah.
All right, sir. So, sir, seeing the time constraints, we have
Yeah.
already surpassed the time by 26 minutes. So, sir, why don't we keep part 2 of this session? Because there are ample of questions on YouTube chat as well, and there are a lot of questions in my chat box here too. And I personally too had a couple of questions regarding how to set up an independent practice in economic offenses, and what are the forensic to which extent forensics are involved, from where to learn all these skills and things like that. So I think we won't be able to cover all this in these puny 1 minute, and people are crazy to hear from you. I'm getting this tremendous response on WhatsApp, on LinkedIn ki mera question pucho. So why don't we keep part 2 of this session, and for now we can just get done with this part.
Definitely, obviously, now that you're asking me in front of everybody, I can't say even no. On a lighter note. So definitely,
all right, sir.
we'll definitely have one more session.
Thank you so much. That's very kind of you, sir. So in the meantime,
Yeah.
I would like to hear from you guys. People, can you rate this session on the scale of 1 to 5? We will be definitely having a part 2, as sir has also promised. But for the meantime, taking the cognizance of this session only, how much did you like this session? Can you rate it on the scale of 1 to 5, with 1 being the lowest and 5 being the highest? On the YouTube chat. Great. 8 out of 10, someone said. Karan Verma, 5 out of 5. Please, people, please send it to me. I'm very eager to hear.
I can't hear you, Anubhav. Are you saying something to me?
No, sir, I was just reading the feedback. Kunal Pandey has given us 8 out of 10. Karan Verma, in the why don't I available this? Everyone publicly. Bharat Advocate, yeah. So now you guys can send even on the public domain of the chat. Please give us a quick feedback.
Very well, Anubhav. I think that's for.
Yeah. Okay, all right. Mainly 5, 4.5. All right, sir. Thank you so much. Thank you so much, people. It has really been great to interacting with you guys. Questions were really insightful. Thank you, Sunil, sir. Sorry. Sorry. Okay. All right, people. Take care. Bye. Break a leg.